In 1959, a woman made a decision that would define the rest of her life. She left. She left the Jehovah's Witnesses. She left Logroño, Spain. She left everything and everyone she knew. She boarded a ship, crossed the Atlantic, and started over in a new continent where no one knew her name, her past, or the organization she had walked away from. For more than 60 years, she lived her life in freedom. She settled in Canada. She grew old. And in 2011, apparently, she died in Ottawa. Then, in 2025, something remarkable happened. The organization she had fled 6 decades earlier walked into a Spanish courtroom. They were not there to honor her memory. They were not there to find out what had happened to her. They were there because they wanted her inheritance. And they wanted a judge to declare her dead so they could collect it. The court looked at what they were asking. The court looked at how they were asking it. And the court told them no. On every single count, the answer was no. If you have ever left a high-control religious organization, you know what it means to walk away. You know the weight of that decision. You know what it costs. The friends who stop speaking to you overnight. The family members who treat you like you no longer exist. The community that was your entire world suddenly closed off, as if someone had slammed a door and locked it behind you. And you probably also know that for some organizations, leaving is never really the end of the story. They find ways to reach back into your life. Sometimes through family. Sometimes through former friends who are told to contact you as part of a campaign to bring you back. And sometimes, as this case shows, through the legal system itself, even after you are dead. The woman at the center of this case is identified in Spanish court documents as Adelina. That may not be her real name. Spanish courts routinely change names in published rulings to protect privacy, under a regulation established by the General Council of the Judiciary back in 1995. But Adelina is how we will know her in this story. Adelina is how the court knew her. And Adelina is how we will remember her. According to the Infobay España report published in January 2026, Adelina left Logroño on May 21, 1959. The headline of that report is explicit. She fled the religious organization. Those are not my words. That is not my interpretation. That is how the Spanish press described her departure. She was not just emigrating to find economic opportunity abroad, though that may have been part of it. She was escaping. Think about what it meant to leave in 1959. There was no internet. No support groups for former members. No YouTube channels documenting the experiences of people who got out. No Reddit communities. No Facebook groups. No podcasts where former members could share their stories and realize they were not alone. If you left in 1959, you left completely alone. You figured it out by yourself. You processed the trauma by yourself. You rebuilt your life by yourself. And you probably never spoke about it again, because there was no one to speak to who would understand. The organization in 1959 was different in some ways from what it is today, but the fundamental dynamics of control and shunning were already in place. If you left, you lost everything. Your social network. Your community. Your sense of identity. Your relationship with family members who stayed in. All of it, gone, the moment you walked away. And Adelina walked away. She did not just leave the organization. She left the country. She put an entire ocean between herself and her former life. She went first to New York, then eventually settled in Canada. And from that point forward, her connection to her old life in Spain grew fainter and fainter until it essentially disappeared. Maybe that was intentional. Maybe she wanted nothing to do with the family and community she had left behind. Maybe some of that family had shunned her when she left, and she decided that if they could cut her off, she could cut them off too. Maybe the distance was not just geographic but emotional, a deliberate severing of ties with a past she wanted to forget. Or maybe it was simpler than that. Maybe letters got lost. Maybe phone calls were too expensive. Maybe time just passed, the way it does, and suddenly decades had gone by and the connections that once seemed important had faded into silence. We do not know the details of her life in Canada. The court documents do not tell us whether she found happiness, whether she built new relationships, whether she ever thought about the organization she had left behind. We do not know if she married, if she had children, if she found a new community that accepted her for who she was. We only know that she lived there for decades. And according to records referenced in the court case, she apparently died in Ottawa on April 26, 2011. That should have been the end of her story. A woman who left, lived, and died far from the organization she had escaped. A woman who got out and stayed out for more than 50 years. Case closed. Life over. Rest in peace. But it was not the end. Because back in Spain, there was unfinished business. And the organization she had left behind had not forgotten about her, or more precisely, had not forgotten about what she might have left behind. When Adelina's parents died, they left a property in Logroño. Under Spanish law, that property was automatically divided among their 3 children, Alvaro, Luis Angel, and Adelina. 1/3 each. No exceptions. Spanish inheritance law is strict about this. You cannot disinherit your children. The share is guaranteed by something called the legitima, a forced inheritance that passes to direct descendants regardless of what the parents might prefer. This means that even if Adelina's parents had wanted to leave her nothing, even if they had disowned her for leaving the organization, even if they had pretended she did not exist, the law would have given her a share anyway. Spanish law protected her inheritance rights even if her own family did not. But Adelina was gone. She had vanished across the Atlantic decades earlier. She was not there to claim her portion. She was not there to sign documents, make decisions, or participate in the management of the family property. Her share simply sat there, frozen, legally untouchable. When Luis Angel died, he left his portion to Alvaro. That simplified things somewhat. 2/3 of the property was now clearly under Alvaro's control. But Adelina's third remained in limbo. It belonged to someone who had disappeared from her family's life long before most of them were even born. And until someone could figure out what had happened to her, until there was legal clarity about whether she was alive or dead, that inheritance remained frozen. Now here is where the story takes its turn. According to the InfoBay report, the organization that eventually filed a petition in Spanish court was identified as Testigos Cristianos de Jehová. They claimed to be what the legal documents called the final beneficiary in the chain of heirs. Stop and think about what that means. They were claiming that through some series of inheritances and bequests, they had become entitled to Adelina's portion of the family property. The woman who left them. The woman who fled. The woman who crossed an ocean to get away from them. Somehow, according to their legal theory, they had ended up with a claim to her inheritance. The organization she escaped from in 1959 was now, in 2025, asking a Spanish court to help them collect what she had left behind. If you have spent time in the organization, you know how this probably happened. You know about the pressure to leave your estate to the organization. You know about the articles in the publications encouraging members to include kingdom interests in their wills. You know about the talks and the examples and the subtle and not-so-subtle suggestions that faithful members should make the organization their beneficiary. And you probably know what happens when elderly members have no close family. When their children have left the organization and been cut off. When their siblings have died. When there is no one left except the congregation. Those members often leave everything to the organization. It is presented as a final act of faithfulness, a way of serving Jehovah even after death. The mechanics of inheritance can create strange chains. When one member dies and leaves their estate to the organization, any inheritance rights that member had pass along too. If that member happened to have a claim to property from a relative who died years earlier, property they never claimed, in a country they left decades ago, that claim can theoretically transfer to whoever inherits from them. We do not know the exact chain the organization claimed in this case. The court documents, as reported by InfoBay, do not spell out every link. But we know the endpoint of their argument. They believed they were entitled to Adelina's share of the family property in Logroño. And to claim it, they needed her to be legally dead. There was just one problem with their plan. Actually, there were several problems. And Spanish courts were about to explain each one of them in detail. To claim the inheritance, the organization first needed Adelina to be declared dead under Spanish law. Not just dead in fact, but dead in the eyes of the legal system. And since they apparently did not have an official death certificate, they tried a different approach. They asked a Spanish court to issue what is called a declaration of death. Under Spanish law, specifically Article 193 of the Civil Code, courts can declare someone dead if they have been missing for a certain period of time. 10 years with no news, generally. 5 years if the person was over 75. The law exists because sometimes people genuinely disappear and families need a way to move forward, to settle estates, to close chapters that have been left painfully open, to find some kind of closure even when they never found a body. But this mechanism was designed for genuine disappearances. For cases where someone vanished and nobody knows what happened to them. Did they die? Did they start a new life somewhere? Were they the victim of violence? The uncertainty is complete. That is when you use this procedure. Not for cases where you actually have information about when and where someone died. And here is the devastating detail that the court seized upon. According to the petition itself, according to the organization's own submission, there was a reference to Adelina's death. April 26, 2011. Ottawa, Canada. They knew. They had information suggesting they knew exactly when and where she died. They just did not have the official paperwork from Canadian authorities. Think about what they were asking. They wanted a Spanish judge to legally declare that Adelina was dead, using a procedure designed for cases of total uncertainty, while simultaneously acknowledging that they had information about the date and place of her death. The court's response was essentially, that is not how any of this works. If you know someone died in Ottawa in 2011, you do not ask a Spanish court to declare them dead using the missing persons procedure. You contact Canadian authorities. You request a death certificate from the province of Ontario. You go through the proper channels, get the document apostilled for international use, and submit it to Spanish authorities. It might take time. It might require navigating bureaucracy. But that is the correct process. The declaration of death mechanism is a last resort for genuine mysteries. It is not a shortcut for organizations that do not want to deal with international paperwork. It is not a tool for avoiding the proper procedures just because those procedures are inconvenient. The petition first landed before the Juzgado de Primera Instancia número 7 in Logroño. This is a court of first instance, the entry point for civil matters in the Spanish system. The judge looked at what was being requested, examined the requirements of the law, and made a decision. The petition was inadmissible. Not rejected after a full hearing on the merits. Thrown out at the threshold because it did not even meet the basic requirements to be considered. The court noted that what the petitioners described was not a disappearance at all. It was a documented migration. Adelina left Spain with a destination. She arrived in New York. She moved to Canada. There were records of this. She had not vanished into thin air. She had emigrated, like millions of other people throughout history, and built a life somewhere else. The organization appealed to the Audiencia Provincial de la Rioja, the regional appellate court. Surely, they thought, a higher court would see things differently. Surely someone would help them unlock this inheritance. The appellate court examined the case with even greater scrutiny. And they agreed with the lower court completely. The mechanism was inappropriate. If there is evidence that someone died at a specific time in a specific place, you obtain the death certificate from that place. You do not ask a court to presume death when you have reason to believe documentation of the actual death exists. The whole point of the declaration of death procedure is to address genuine uncertainty. When you already know the date and place of death, there is no uncertainty to resolve. But the court went further. They addressed another fundamental problem. Did the organization even have the right to bring this petition in the first place? In legal terms, this is called standing. To ask a court to do something, you have to prove that you have a legitimate interest in the outcome. You cannot just walk in off the street and demand that a judge declare someone dead because you think you might benefit from it. The organization claimed to be the final beneficiaries in the inheritance chain. But according to the court, they did not prove it. They asserted it. They stated it as if it were obvious. But they did not demonstrate it with documentation. They did not show the chain of wills and deaths and bequests that would connect them to Adelina. They did not prove they had any legal right to her inheritance at all. They expected the court to take their word for it. The court declined. And what evidence did they submit to support their claim that Adelina was dead? According to the Infobay report, Their documentation included a record from Ancestry, the genealogy website. They found a reference to her death online and presented that to a Spanish court as if it were official documentation. Ancestry is a useful tool. Millions of people use it to research their family histories. It has helped countless individuals find long-lost relatives and piece together their family trees. But it is not a government registry. A record on Ancestry is not a death certificate. It is information compiled from various sources, some official government records, some user-submitted family trees, some automated database matching. The information can be incomplete. It can be inaccurate. It can be simply wrong. Spanish courts require official documentation for matters this serious. They require authenticated records from the relevant government authorities. They do not make legal determinations that affect property rights and inheritance based on what someone found on a genealogy website. On September 26, 2025, the Audiencia Provincial de La Rioja issued its final ruling. The appeal was dismissed. The petition remained inadmissible. The organization was ordered to pay the legal costs of the proceedings, and the case was closed, permanently, with no further avenue for appeal. The organization failed on every front. They chose the wrong legal mechanism. The declaration of death procedure is for genuine disappearances, not for cases where you have information about when and where someone died. They submitted insufficient evidence. A genealogy website is not an official death certificate, and they could not prove they had any right to bring the case in the first place. Claiming to be an heir is not the same as proving you are an heir. 3 strikes. Case over. Inheritance remains out of their reach. For anyone who has left the Jehovah's Witnesses, this case might feel familiar in some ways and shocking in others. Familiar because you know how the organization operates. You know the emphasis on leaving everything to kingdom interests. You know about wills and estates and the pressure that members face to make the organization their beneficiary. You know about the articles suggesting that this is what faithful servants do. You have probably heard stories of families torn apart over inheritance, of estates that ended up going to the organization instead of to relatives who had been shunned for leaving. But shocking because of the reach. Because of the audacity. Because of what it reveals about how the organization views people who left. A woman leaves in 1959. She spends more than 60 years living her own life, free from the organization, on another continent. She dies in Ottawa in 2011. 14 years pass after her death. And then, in 2025, the organization she fled shows up in a Spanish courtroom asking for her inheritance. 66 years after she left. 14 years after she died. And still, they came. Still, they tried to claim what she left behind, even though she fled. Even though she clearly wanted nothing to do with them. Even though 6 decades of silence should have made her wishes absolutely clear. Some people who have left high-control groups talk about feeling like they can never truly escape. Like the organization will always be there, somewhere in the background, watching, waiting, ready to reach back into their lives at any moment. Parents report their adult children to elders. Former friends show up unannounced years later trying to bring you back. Family members treat you as dead while you are still alive. This case is a literal legal example of that dynamic. Adelina got out. She stayed out for her entire adult life. She died out, far from the organization, in a country she had chosen for herself. And still they came for what she left behind. If that does not tell you something about how this organization views former members, I do not know what would. But here is the other side of this story, and it is the side worth focusing on. The court said no. The Spanish legal system looked at this petition and rejected it completely. Not on a technicality. Not on some minor procedural point that a better lawyer might have avoided. On fundamental grounds. The mechanism was wrong for this situation. The evidence was inadequate. The standing was unproven. The entire approach was legally deficient from start to finish. The organization could not simply walk into court and claim an inheritance from someone who fled them 6 decades earlier. They had to prove their case. They had to follow the proper procedures. They had to demonstrate that they had a legal right to what they were claiming. And they could not do any of those things. In a world where it sometimes feels like powerful organizations always get their way, where money and influence can bend the rules, where legal systems favor those with resources over those without. This is a case where the system worked exactly as it should. A woman who left was protected, even after death, from the organization she escaped. Her inheritance, whatever it might be worth, remains out of their reach. The court saw what they were trying to do, and the court said no. We should be careful not to draw sweeping conclusions from a single court case. This is one petition in one region of Spain involving one specific set of facts. The court's decision applies to this situation, not necessarily to any broader pattern. We do not know how many similar attempts have been made in other jurisdictions. We do not know how many have succeeded. But it is worth noting what the Spanish courts made absolutely clear. There are rules. There are procedures. And they apply to everyone, including religious organizations. If you want to claim an inheritance, you have to prove your connection to it. If you want a court to declare someone dead, you have to meet the legal requirements. If you have information about when and where someone actually died, you have to pursue the proper documentation instead of trying to take shortcuts. The organization in this case did not do these things. And they lost. Completely and totally. Adelina left Logroño in 1959. She crossed the ocean. She built a life in Canada, far from the organization she had fled. She lived in freedom for more than 50 years. She made her own choices. She lived on her own terms. And when she died in Ottawa in 2011, she died as someone who had gotten out and stayed out. 66 years after she left, the organization tried to reach back across time and across the Atlantic to claim what she had left behind. The Spanish courts told them no. The petition was inadmissible. The appeal was denied. The costs were imposed. The case was permanently closed. For Adelina, whatever her real name was, wherever her remains might rest, there is a kind of justice in this outcome. She escaped. She stayed escaped. And even in death, even when she was no longer here to defend herself, the legal system protected her from the organization she had walked away from all those years ago. The organization did not get her inheritance. They got a court order to pay legal costs and a permanent rejection on the record. That is what happens when you try to take shortcuts. That is what happens when you cannot prove your case. That is what happens when the answer is no. What do you think about this case? Does it surprise you that an organization would pursue an inheritance from someone who left them more than 60 years earlier? Have you heard of similar situations in your own experience or community? What does it say about how some organizations view former members? Not as people who made a choice to leave, but as resources that still somehow belong to them. Drop your thoughts in the comments. If you are someone who has left, know that your story matters. Know that you are not alone. And know that sometimes, even against wealthy and powerful organizations, the legal system does its job. Sometimes the answer is no. And sometimes no is exactly what justice looks like. Subscribe if you want to see more content like this. Hit the bell so you do not miss what comes next. Because there are more stories out there. More court cases. More documents. More evidence of how these organizations operate when they think no one is paying attention. But people are watching now. And we are going to keep telling these stories until everyone knows the truth.